trials and how it works. So they decide they're going to go to trial. Nobody plea bargains. They decide they're going to go to trial. So you have a defense attorney and you have a prosecuting attorney. The first thing that happens is the prosecutor has to turn over all the evidence to the defense. He has to show the defense what evidence they have against their client. And this is known as discovery. It's a pretrial process by which each side tries to gain vital information, such as police records, about the case that will be presented by the other side. So the defense will present their material as well. From time to time, the defense will present material that convinces the prosecution that they don't have a case, and they'll drop the case. That does happen. This all happens in discovery. The first thing that happens, they draw up a panel of prospective jurors. This is known as a veneer or a venire. For a large, it all depends on whether you're pronouncing it Italian or whether you're pronouncing it like an American who can't speak foreign languages. So it's either a veneer or a venire. It's usually based on voter registration lists and lists of licensed drivers. I have been in jury pools. They always disqualify me, and the reason they disqualify me is because I'm a psychologist. That and the fact that I have so much education.
Really?
Yeah, they don't. Neither side wants me on their jury. There's a couple other different reasons. Well, one reason is because they think I'll try the case instead of, I won't act as a juror, I'll act as a lawyer. Which I probably would do. Actually, my brother was on a jury one time. It was a murder trial, and my brother's probably smarter than I am. I don't know what his IQ is, but he's probably smarter than I am. He reads a lot. He reads everything. He reads anything. He's got a house full. He probably has 10,000, 15,000 books in his house. He's read them all. He reads everything. So he knows everything. I mean, that's my brother.
So how do you get out of jury duty? Do you let them know I read about this case?
Oh, I just give them that information.
I've read a lot about this case.
Yeah,
I read a lot about this case.
I just give them that information. And normally they don't pick me. They just don't pick me. And I don't even, they usually disqualify me before I even go in. That's what happened in Montana. Well, my brother was on a jury, and he actually did try the case himself. What happened, the prosecuting attorney presented his material, the defense attorney presented his material, and then they went into deliberation, and my brother retried the case in the jury room. If they'd ever discovered what he did, they probably would have thrown the case out. Well, what he did, like I said, he knows everything. And he's a combat veteran. And this was a case where it was a domestic violence situation. And the woman was attacking the man with a butcher knife. And she cut his arms all up, and she got him in the chest a couple times. And she got him in the neck one time.
Is that your story?
I'm sorry? Yeah, it sounds like my wife.
You?
No, she didn't stab me that many times. So he took the butcher knife away from her. And so he's holding on to this butcher knife, and she runs into the bedroom and pulls out a pistol. She pulls out a pistol. It's a revolver, and evidently it's got a hair trigger, or it's one of those, I don't know how much you've shot guns, but usually it's really hard to hold, and then all of a sudden it just goes off. Yeah, so you don't know when the damn trigger's when you're going to trip the trigger, as it were. So that was the situation with this gun. So she goes and she gets this revolver, and she starts swinging it in his face, and she starts to pull the trigger. He pulls the gun away from her, and as he does, of course, it discharges. and it just discharges into her chest. But it hit her in the sternum. Unfortunately, it hit her in the sternum and it ricocheted over. It wasn't a very high caliber weapon. It was like a 22, well, it wasn't a 22, it was like a 25 or 27. I mean, it was really kind of one of these guns that they make 5 rounds of ammunition for. Anyway, the thing went off and it bounced off of her sternum and it ricocheted right into her heart and killed her. So they wanted to convict him of first-degree murder because of the fight, and they thought he got angry and killed his wife. But my brother went through all the evidence that they had, and he went through all the police reports. and of course, they thought the deliberation would take 2 or 3 hours. It took 3 days for them to retry the case. And of course, the judge got all pissed off. And it was involuntary manslaughter is what they ended up with. So they charged him with involuntary manslaughter. But otherwise, but that wasn't even part of the case. They had to call the judge in and they said, we don't think that it's first-degree murder. And he said, well, you're going to have to let it go. And they said, no, it's not really, we can't do that. It's involuntary manslaughter.
I thought they weren't supposed to try a person twice for a criminal case.
They didn't try him twice. They only tried him once, and the jury is the one, the juries went back through the case, is what happened. And they made the deliberation. The judge was all pissed off. The judge wasn't a very good judge anymore. But he blackballed my brother, so my brother was never be on that jury again. So every time his name comes up, they just kind of toss it out, just kind of like my name. Anyway, okay, so that's the, once the venire is, for a trial has been selected, a process known as voir dire occurs where they question the jurors. In most states, the defense can disqualify more jurors than the prosecution can. The prosecution isn't really supposed to disqualify anybody in most states. The opening statements, the first person to speak is the prosecution. In most cases, the lawyers for each side are permitted to make opening statements. There's no evidence presented, of course, they just talk to the jury. The prosecution or the plaintiff usually goes first. Defense's opening follows immediately after the prosecution, or they can decide that they won't make an opening statement until they start presenting their evidence. And then the prosecution gets to talk again if they want to. After opening statements, the prosecution or plaintiff calls its witnesses, so the prosecution goes first. Each witness testifies under oath with the threat of a charge of perjury if the witness fails to be truthful. This is a huge deal because this is going on right now, of course, in the nation's capital. There's an impeachment inquiry going on, and they're deposing all of these individuals that have evidence, theoretical evidence about what happened with that famous telephone call between President Zelensky of Ukraine and President Trump. So this is going on right now. Now the interesting thing is this whole concept of perjury. Can you lie under oath? And the answer is no. If you lie under oath, it's perjury, and then they're supposed to prosecute you for perjury. But there's a lot of misinterpretation going on. It should be interesting to see if anybody is actually charged with perjury, because we have pieces of information. We have pieces of information that we know are true, and other people have said, no, that's not what happened. So we'll see if they charge them with perjury. Each witness undergoes direct examination, cross-examination, redirect, or recross. So this is the prosecution examines them, and then the defense attorney will cross-examine them, and then the prosecution will redirect. In other words, they will talk about the cross-examination, and then the defense attorney will get to recross. Okay, yeah, and that's for one witness. So this can take a really, really long time. If you've been keeping up with what's going on in Washington, sometimes these people are testifying for hours. The one yesterday, of course, they had that big brouhaha yesterday, where the Republicans charged
The hearing.
they came.
I saw something about Trump using the word lynch too.
Yeah. They used the word,
Lynching.
he pissed like everybody off. Everybody's pissed. Except the Republicans. The Republicans are going, this is really a lynching. No, a lynching is where you hang somebody. Or you kill them in one way or another. They're not actually killing anybody yet. So we'll see what happens. I know, he used the word lynch, and of course it's an inflammatory word. Most of the people that were lynched in the United States were African American. So it's one of those words, like the N-word. I mean, it's just a word that nobody uses because it refers to a really ugly, negative
It would be
timing.
simpler to say scalped, right?
I'm sorry?
It would be something similar to saying scalped.
Exactly. If somebody used the word scalped, we would all be in trouble. I'll try not to say that word. I'll try to control myself. Exactly. After the prosecution or the plaintiff's attorneys have presented all their witnesses, it is the defense's turn. Each witness undergoes direct examination, cross-examination, redirect, and recross. And this is one of the reasons why it takes such a long time. Has anybody ever been a part of a trial? Have you ever been a witness in a trial? I have been. It's always fascinating to be a witness. Everybody gets to talk to you. Except the judge. The judge can't ask any questions. After both sides have been presented, their witnesses, one or both may decide to ask the judge for permission to present rebuttal evidence, which attempts to counteract or disprove evidence given by an earlier witness. And you can do this in most trials. It all depends on the state. Some states you can rebut evidence right away. In other states you have to wait until the prosecution is finished or the defense is finished to rebut their evidence. All depends on the state. Once all the evidence has been presented, each side is permitted to make a closing argument, and this is known as a summation. Typically, the prosecution or the plaintiff gets the first summation. So the prosecution gets to say, this is why this person is guilty. And then the defense gets to sum up their idea of what's going on. And so they will say that, no, my client is innocent, or my client didn't really mean to do it, or whatever their defense strategy is. And then strangely enough, the prosecution gets to talk again and say why the summation of the defense was inaccurate. So the prosecution actually gets to talk twice at the end of the trial. And the defense only gets to talk once. The final step in the jury trial is for the judge to give instructions to the jury. He will tell them what the laws are, what laws they're trying to decide, and then he will send them away to deliberate. The judge also instructs jurors about the standard they should use to weigh the evidence. This is kind of tough. Everybody has their own ideas about things, but he tells them how they have to, whether this piece of evidence is more important than that piece of evidence. With criminal charges, the jurors must be convinced beyond a reasonable doubt that the defendant is guilty before they vote to convict. In most criminal trials, it has to be unanimous. Well, maybe not. Well, I guess it all depends on the state. In capital crimes, it has to be unanimous. So if they're going to, if they want to convict somebody of first-degree murder, well, as in the case that my brother saw, it has to be unanimous. And of course, he wasn't going to convict anyway. I mean, he had already decided from the evidence that that's not that that's not what should have happened. They actually let them have the gun. And my brother showed them how the pistol worked. The fact that it had a sticky trigger, is what we called it. And you never knew when the thing was going to go off. In a civil trial, the preponderance of the evidence is necessary for finding in favor of one side or the other. Preponderance of evidence. When the jury has reached its verdict, its foreperson informs the bailiff, who informs the judge, who reconvenes the attorneys and defendants and plaintiffs, of course, in the civil trial for an announcement of the verdict, and then they read the verdict just like they do on television. It's kind of exciting. Usually, well, it all depends on the state. In some states, the judge reads the verdict. In some states, the foreman of the jury reads the verdict. Advantages to the prosecution. The prosecution is first to address the judge or jury. It has the full resources of the government behind it. The prosecution presents its evidence before the defense does. At the end of the trial, the prosecution gets to go first and also gets the chance to offer a final rebuttal to the defense's closing argument, which doesn't seem very fair. But the reality is they have to prove their case, and that's what we're going to talk about next. There are advantages to the defense. The defense doesn't have to prove anything. The defense doesn't have the burden of proof. That's the government has the burden of proof. So they have to prove that this is what happened. The defense can just sit there and not say anything if they want. The prosecution must turn over exculpatory evidence. In other words, this is in discovery. They have to give them all the evidence that there is out there. So if it's a murder trial and they think that this guy's the one that did it, but they haven't looked for any other suspects, then of course that wouldn't, and there is a possibility that somebody else is the murderer, then of course that's the way it works.
What if you always find something?
Some judges won't allow that to be presented, and for that reason, the individual will be convicted, and then it has to go to appeals. If there's exculpatory evidence that comes out after the trial starts. This is one of the reasons why it takes so long for the trials to come to court. They have to make sure they've got all the evidence that there is to have. And this is the job of the police department, of law enforcement, is to find all the evidence. And find all the evidence before the trial starts. And that's the job of the district attorney, is to make sure that all that evidence is available.
Does all evidence need to be presented before the case starts, or do people usually bring in different or new evidence during the trial?
It's supposed to come up before the trial starts. If it comes up after the trial has started, judges have the right not to accept it.
But they can, right?
They can accept it, well, it depends on the state. In some states, they would have to call a mistrial and then retry the case. But in other states, they can bring in new evidence. California does that, and it's one of the reasons why, if we're watching a television show in California, this is what happens, but if you're in Nevada, you can't bring in new evidence. They have to call a mistrial and then start the
So
trial.
even the prosecution can call a mistrial if they find new evidence. That would help their case.
No, the judge has to call the mistrial. Prosecution can't do it. Prosecution can bring in new evidence and say, we have new evidence, and then the judge will call the mistrial. That's usually the way it works. But he doesn't have to. He can say, well, this evidence isn't important enough. But then, of course, there's always a possibility that they will throw the case out anyway in appeals, because he wouldn't allow evidence to be presented at the trial. He can throw out any evidence that he wants. He can throw out a confession if he wants, or she, whichever the case may be. Of course, judges, we're right at 50% female and male judges. So if we see them on television, they're almost always males. But that's not the way it is. As a matter of fact, Wait a minute. One of my divorces was in front of a female judge, and one was in front of a male judge. The female judge made a lot more sense. The male judge was a Baptist minister, pastor. He was not a good judge. Anyway. What are we talking about this? Okay. The defense may have more opportunities than the prosecution to remove potential jurors without giving a reason. Usually that's the way it is in most states. Some states, they have an equal number of vetoes. They don't call them vetoes, they have another name for it, but they can exclude select jurors. They're looking for a certain type of juror normally. If you've ever watched Bull, which is really an irritating television show, but if you've ever watched Bull, he seems to know who's going to find in his favor against another juror. But the reality is that they usually do things like, and I think we're going to talk about this later, but they usually assume that if it's a black defendant, that a black juror will be more sensitive to the individual's plight, and they are less likely to convict if they have a black juror. The assumption is that females are more empathic than males are, so if it's a violent crime, then she's less likely to convict than a male is. There's a lot of strange ideas out there. And some of them are true and some of them aren't. Defendants do not have to take the stand as witnesses on their own behalf. Defendants who are found not guilty can never be tried again for their specific crime. The problem with the defendants taking the stand is that it looks like they're whining, it looks like they're making excuses for what happened, and for that reason, of course, they don't impress the jury very favorably. So a lot of times they won't allow them to testify. If the defendant in a criminal trial is judged guilty, a punishment must be decided. In most jurisdictions, the trial judge decides the punishment. In some cases, in some states, the jury gets to decide the punishment, which is kind of interesting. In a lot of states, they will have the individuals that were injured, the injured parties, will be part of the deliberation as to what the punishment should be. This is what was supposed to happen down in Florida with Jeffrey Epstein. He was convicted of trafficking and statutory rape because he was having sex with underage girls. I was talking to somebody last night and they said that his favorite age was 12. So a lot of this stuff doesn't make any sense. Anyway, so the individuals that were injured, the injured parties, in some states are allowed to come in and make suggestions as to what should happen to the individual. And that's what was supposed to happen in Florida, but it didn't happen. They didn't allow them to come in. They didn't even know what happened in the case, even though they were the ones that testified against him. In order for them to get any remuneration from damages, to get damages from Jeffrey Epstein, they would have had to have sued him in civil court. And evidently, they thought that the criminal trial was still taking place, and the state had already made a decision and allowed him to leave the state, which isn't what was supposed to happen. And that's one of the reasons why what actually happened was, of course, he was being tried, and it was kind of a secret deliberation was taking place. And then all of a sudden, he was gone. He just disappeared. So a reporter for the Miami Herald went out and got all the evidence from the young ladies that had been molested by him. And so she wrote an expose about what was going on with Jeffrey Epstein. Well, eventually, of course, the expose reached New York City, and of course, New York City, he also had an apartment in New York. He had an apartment in Miami and an apartment in New York. And he was doing the same thing in New York, of course. He was kind of a, I don't know what the word to use other than horn dog would be. He seemed to be having sex a lot, daily. And of course, he had molested girls in New York. So New York started investigating, and they had all this evidence against him. And as soon as he landed in New York, they arrested him, put him in prison, and then he committed suicide. But he was free. Florida had let him go. Why? I mean, he committed a crime, so why would they let him go? What rationale did they have for letting him go? What positive thing happened to allow this man to go free, despite the fact that he had been convicted of trafficking and statutory rape? Why did they let him go? Because he's white?
Oh,
Well, that's one reason, I guess. What was the other reason? Because he was wealthy? That's the real reason. They let him go because he was wealthy. So what happened with the owner of the Patriots? Why is that case all of a sudden nobody cares about it? Is he another rich white guy?
mhm.
Why did Donald Trump say that he could shoot somebody on Fifth Avenue and nobody would care?
Because he has money.
Because he's got lots and lots of money. Now lawyers
Or
are...
he claims to have money.
Yeah, I guess we'll find out. Well, it doesn't make any difference. If people perceive that he has money, then I guess that's the same as having money. It's just a perception. Do I look like I have money? I'm white. I'm old, I'm white. Do I have money? I do. I have $5 in change in the pocket. $5.
So he filed bankruptcy? Is that what he does?
Who, Donald Trump?
Yeah.
Yeah.
But how's that the case if he has billions of dollars?
This is the way it works with bankruptcy. Bankruptcy has to do with here, right here and now, okay? It has to do with the Taj Mahal in Jersey City. It just has to do with the Taj Mahal. So if I'm losing money on the Taj Mahal, I can declare bankruptcy. But it just has to do with this entity. It just has to do with that. It just has to do with what I own in New Jersey. It doesn't have anything to do with what I own in New York City or what I own in Pittsburgh or Los Angeles or Las Vegas. So I can declare bankruptcy in New Jersey, and that means that all my assets in New Jersey are, I have to pay pennies on the dollar for all my debts. So it works.
So,
But I can't open another business in New Jersey for 10 years.
a person is only allowed to file bankruptcy 3 times, right? In their life. Or did that, you can file as many times as you want.
It all depends on where you are. If you own 50 different properties in 50 different states, you can file bankruptcy 50 different times. But if you live in Arizona and you don't only live in Arizona, if you only live in Arizona, then you can only declare bankruptcy 3 times.
All these loopholes.
I'm moving. I'm going someplace else where I can declare bankruptcy. My daughter declared bankruptcy in Florida. I heard the baby daddy, he ran up her credit card debt, and so she had to declare bankruptcy. But now she lives in Iowa. So they don't have to loan her money in Iowa, but her bankruptcy in Florida is known by the people in Iowa, but they can give her credit if they want to. She can't get credit in Florida, but she can get credit in Iowa.
That's interesting.
Just the way it works. Sure, you can go someplace else and start over. Well, that was part of the whole controversy, was the fact that he had declared bankruptcy 3 times in 3 different states, and he was still able to get billions of dollars in loans from the Deutsche Bank in Germany. But he couldn't get loans from any bank in the United States. He could only get loans from the German banks. The question is, why in the world would they loan him money if nobody in the United States will loan him money? That was the question. So now they're trying to get the records from the Deutsche Bank to find out how in the world well, that's what Congress is doing. The Republicans are claiming that the Democrats are trying to lynch him. I don't think they're going to lynch him. In 2004 decision, the United States Supreme Court ruled that judges may not increase defendants' sentences on the basis of what they perceive as aggravating factors, circumstances that seem to make the crime worse. He had well, in most states, if you commit a crime with a weapon, then the sentencing is more severe. But if it was a especially grotesque crime where he mutilated the individual, then they can't charge you with murder plus mutilation. They can't do that. They can't throw the book at him because of the extra things that he did in his crime. In Blakely versus Washington in 2004, the court reserved these determinations for juries. Only juries could make that deliberation, not the judge. So it had to do with the juries. And this is actually Blakely, that was the individual that mutilated the young lady that he raped. And because of that, the judge wanted to throw the book at him, keep him in jail, put him in jail for life. But of course, they wouldn't allow that to happen. The jury just charged him with rape. And they couldn't do anything about it. In a handful of states, sentencing is determined by a jury. In cases involving the death penalty, jurors, rather than the judges, decide the sentence. And this was decided in a case, Ring versus Arizona in 2002. And that's actually Ring right there. The jury decided that he should be put in prison forever. The judge wanted to execute him, but the jury said no. Any defendant has the opportunity to appeal a verdict to a higher level of courts. Appeals are also possible in virtually every civil suit. This is one of the reasons that a lot of people never pay in civil suits. They can get a decision that they're supposed to pay $200 million, and they'll never pay a penny. They'll just keep it in the appeals courts for an extended length of time. That's what happened with the Bell telephone case that I was part of. It just stayed in the courts for years. Most of the defendants were military personnel, and half the defendants were dead. They had died in the war. So there you go. Nobody got any money out of it. But so how did Bell Telephone get out of having to pay all that money? They got out of it by breaking up the company, declaring bankruptcy. Ma Bell didn't exist anymore. Now they're AT&T. They're not the same company. So, and they forced them to change their long distance regulations. And now, of course, we've got satellite, so we don't have to worry about landlines. In the old days, everything was a landline. So if you called long distance, if I called from Lubbock, Texas to Indiana, it would take probably 15, 20, 30 seconds for the call to go through. And what Bell Telephone was doing, they were charging you from when you made the call. It didn't matter how long you talked on the phone. It mattered when you started the call. And you had to pay, if you went over 3 minutes, then you paid for another 3 minutes right away. Even if you hung up the phone at 3 minutes and 3 seconds, they would charge you for that extra 3 minutes because you're tying up the lines. This was all in the court deposition. It was fun. For an appeal, the appellate judges read the record, the transcript of the trial proceedings, the pleadings, motions, and accompanying documents filed by the attorneys, the briefs, written arguments for both sides about the issues on appeal, and then they decide whether to overturn the original trial decision or to let it stand. So an appeals court will hear a case, or they will read, actually they will read a case, they don't really hear the case, they read the case, and then they decide whether to allow the judgment to stand. That's what's going on with everything that's happening in Washington, D.C. Trump has lost he's lost his appeal to keep his taxes secret, and now there's no other place for it to go except for the Supreme Court. But the Supreme Court normally does not hear tax cases. They allow the appeals court to hear those cases, and then they just stand by whatever that ruling is. So potentially what's going to happen, they won't even hear the case. But he has the right to take it to the Supreme Court. So now the Supreme Court has to make a decision whether they will read the case or not. And that's what's going on right now. And this should be decided fairly quickly because they are in session right now. So they can decide what cases they're going to hear. Now the Chief Justice of the Supreme Court is the one that decides what cases they will hear. And of course he's a conservative Republican. He was appointed by George W. Bush. It's John Roberts. So we'll see what happens. I'm guessing they won't hear the case. There is already a precedent set that they don't hear tax cases, so we'll see what happens. Appellate judges rarely reverse a verdict on the basis of the facts of the case or the apparent legitimacy of the verdict, so they can only read certain aspects of the case. When they do reverse a case, it's usually because they believe that the trial judge made a procedural error, such as allowing controversial evidence to be presented. And that's usually the only reason that they will overthrow a case or that they will hear a case. Normally they just let it stand. The assumption is that all judges are good and all judges hear cases properly. But sometimes, of course, they will allow things to happen that shouldn't have happened. And then they overthrow the case. They overturn the case. If a verdict in a criminal trial is overturned or reversed, the appeals court will either order a retrial or order the charges thrown out. Normally what they will do is order a retrial if there was a procedural problem. In a civil case, an appellate court can let the decision stand. They can reverse it, rule in favor of the side that lost, or make some other changes in the decision and remand or return the case to the lower court for reconsideration. Okay, now you understand why it takes such a long time for these cases to be finalized. And as in the case with AT&T, it just kept bouncing around in all the appellate courts. Now this was, unfortunately the case was presented in Texas. Texas has a very, very, very conservative court system. And for that reason, it bounced around in Texas for about 10 years. And then finally it got out of Texas and went to the regional court. And at that stage, of course, they lost. AT&T lost. I'm sorry, Bell Telephone lost. And they saw the writing on the wall. They knew that they were going to be seen as a monopoly, and that they would have to break things up. So they did. They broke up into 5 different companies. Bell Telephone used to own all the telephones in the United States. You couldn't call it, all the telephones in the United States were owned by Bell Telephone. So Western Electric are the ones that made the telephones. So if you didn't have a Western Electric telephone, you couldn't plug it into a jack. As a matter of fact, Bell Telephone had how can I say this? It wasn't a secret jack, but it was a jack that nobody else was able to reproduce, theoretically. So you couldn't tie into the telephone lines unless you had a Western Electric telephone. So you had to buy your telephones. This is a real ripoff. You had to buy your telephone in order, that's where the Princess Line telephone came in. It was the reason, you had like a choice of 5 different telephones that you could have. That was the deal. So they broke off. I mean, they had to do away with Western Electric. Western Electric still exists, of course. They do research, telephone research. As much fun as that is. Why am I talking about this? Okay, so the courtroom of the future, what is it going to look like? Video conferencing that permits live two-way video audio communication, electronic and digital evidence, computer animations and simulations, which are not allowed in courts today, but potentially they will be in the future. Virtual environment technologies that allow observers to experience a recreation of an event as if they were actually present when it occurred. And now I have a video for you, maybe. I find Idiocracy. This is a scene from Idiocracy, one of my favorite movies. This is what's going to happen if we legalize marijuana in the United States. We're going to have a lot of really stupid people.
If you don't read.
Because nobody reads anymore. Exactly. Okay. Let's see if I can do this.
President Camacho.
From the Army experiment. There was real, she was from the same experiment.
Joe was arrested for not paying his hospital bill and not having his UPC tattoo. We would soon discover that in the future, justice was not only blind, but had become rather retarded as well.
I'm fixing to commensurate this trial here. We don't see if we can come up with a verdict up in here. Now, since y'all say you ain't got no money, we have proprietarily obtained for you one of them court-appointed lawyers. So put your hands together and give it up for Rico Pendejo. You're my lawyer?
Says here you,
Not your feet.
robbed a hospital? Why'd you do that?
Yeah, I'm not guilty.
That's not what the other lawyer said.
Look, listen, you gotta get me on the stand, okay? I can explain everything. We can take him to your house. We'll show him the
Shut
problem
up!
that came
Shut
here.
up! Shut up! Prosecutor, why you think you done it? Okay, number one, Your Honor. Just look at him.
He talks like a fag, too.
We've got all this, like, evidence. So, like, this guy didn't even pay at the hospital. And I heard that he doesn't even have his tattoo. I know, and I'm off. You gotta be shitting me. But check this out, man. Judge should be like, guilty. Peace.
Jackson!
What are you objectifying on?
Come on, just get me on the stand.
Okay. Your Honor, I object that this guy also broke my apartment and shit. Yeah. And you know what else? I object that he's not gonna have any money to pay me after he pays back all the money he stole from the hospital.
Say I stole. You're my lawyer.
And I object that he interrupted me while I was watching Oh My Balls! That is not okay! And I rest my case!
I'm pretty sure we have a mistrial here, sir.
I'm gonna mistrial my foot up your ass, you don't shut up!
Please listen.
Please listen!
I didn't steal anything. I was part of an Army experiment.
Joe stated his case logically and passionately, but his perceived effeminate voice only drew big gales of stupid laughter. Without adequate legal representation, Joe was given a stiff sentence. Meanwhile,
We're not going to get to see what meanwhile happened. Anyway. Yes, the law courts of the future with all the idiots.
Is that a cocaine mallet he was using as a gavel?
Was that a croquet mallet he was using as a gavel?
Yeah, well, it was huge. I don't know how he ever swung it. Okay. That's not right.
Every time we go into at Costco's, my daughter will say, "Welcome Costco's, I love you." So she says when she gets a job, she's gonna start saying that to people. That's how she's gonna greet people from now on in her job. Hello, welcome to so-and-so, I love you.
I love you. There's a Costco in Farmington?
Yeah.
Ah.
I know,
Costco.
meetings, yeah,
Only
only use Sam's Club.
Never go to Farmington, maybe that's my problem. Okay, chapter 9. I think this is the 10th week, so I'm a chapter behind. This chapter is about alternatives to traditional prosecution. We're going to talk about alternative courts rather than the criminal court system that we've always had in the United States. Most cases are resolved through negotiation or by alternative dispute resolution, also known as ADR. Very few cases are settled in trials. As we said before, most are plea bargained down. Only 5 to 10% actually ever go to trial. In 2009, only 1.2% of the federal civil cases were decided in a trial. In 2002, only 4.7% of criminal cases involved a trial. So as you can see, if we look at the history of what's going on in the United States, most of these things are plea bargained down. Plea bargain so that it doesn't go to trial. And of course, trials are very expensive. They take time. They take judges away from other decisions. They take jurors away from their jobs. So these don't really happen all that often. Many cases are settled by negotiation without the assistance of a third party. Negotiation might be formal, as happens when management and union representatives negotiate a labor contract, or informal, as what happens in collaborative divorces. My daughter got a divorce 3 years ago down in Florida, and it was supposed to be a collaborative divorce, but we won't go into how much of an asshole her baby daddy was. It wasn't a divorce case, it was a child custody case. They'd never been married, so it couldn't have been a divorce case. Arbitration is one form of alternative dispute resolution. When the parties agree to binding arbitration, they agree to accept the decision of an arbitrator. And this is what happened in the child custody case that my daughter had down in Florida. It was very expensive. But luckily, that was the semester that, what was his name, Jones? The guy quit over in Tuba City. So we had 6 extra classes we had to teach, Sarah and I taught 5 of them. So I got this huge pile of money from teaching, a double load, which I'm doing right now, as a matter of fact. So we'll see what happens. But they don't want to pay me. Well, you guys know all about this. Anyway, in non-binding arbitration, if one of the parties is dissatisfied with the arbitrator's decision, that person may ask the case to be tried before a judge or jury. So that that's a non-binding arbitration. In binding arbitration, they don't have a choice. If they accept binding arbitration, they have to accept what the arbitrator decides. That's what happens in baseball and football and basketball. They will have wage arbitrators that will decide how much money they can make, or how much money they will make. And sometimes they win, and sometimes they get they really don't win. So and it's usually binding arbitration. Arbitration, whether binding or non-binding, uses trial-like procedures. The parties present their evidence and argue the case, and the arbitrator makes a decision. In recent years, arbitration has been criticized for being overly formal and time-consuming. It is time-consuming. It's a trial without a judge, is what it actually is. Summary jury trial is like a conventional jury trial, though shorter. In this, in a summary jury trial, they will try the case without the defendant. The defendant is usually not there. They will get together. This is the way the military does it. This is the way most court-martials work. Court-martial in the military, they will get together. They will accumulate all the evidence. They will present it to a panel, and then they will have the court-martial, or they won't have the court-martial. The reason they do it this way is because it's a lot faster. It's not like a trial. The court-martial is not like a trial. Because they've already seen all the evidence. And because of that, there's not any arguing back and forth. So any court-martial you've seen on television probably presented it as if it was a trial, but that's not the way it works. Usually what will happen is one side will present all the evidence, which the jury and the panel has already seen, and then the other side will present all their evidence, but they've already made a decision in a court-martial. That's the way it works, and they already know what's going to happen. It's almost like I don't know. I can't even think of what I was thinking of. Anyway, okay. Lawyers tell jurors that the witnesses would say if they were present. The lawyers argue the case and try to answer jurors' questions about the facts. The judge tells the jury what the law is and tries to answer jurors' questions about the law. The jurors then will deliberate, and of course the decision is already made. The individual that is being tried isn't even in the courtroom. They are in the courtroom for the decision, but they're not in the courtroom for any of the rest of the trial. A summary court-martial. I'm sorry, a summary jury trial.
So would it be similar to our Navajo peacemaking court?
I don't
So where
know
there's
how you
really
guys
no
do that.
evidence and anything like that, it's kind of just like arbitrary, or even just being told, we're not gonna look at this, we're not gonna look at that, we're not gonna listen to this or this or
Right.
that, this is what you guys need to
Yeah, it really cuts down on arguments.
do. Yeah.
Yeah, because neither family is in the room at the time. Yeah, that works. Because then it turns into a he said, she said situation.
Yeah, real quick.
Yeah, well, yeah. And both sides want to punch each other. In recent years, verdicts from a summary jury trial have become binding and enforceable in some states, not in all states. This process educates the lawyers and clients on how a conventional jury might view the facts of the laws. Of course, summary trials are usually binding, but they can be appealed, and they can be appealed to a judge. Normally is the way it works. Once educated, the lawyers and their clients are more amenable to settling the case. So the reality is, when they go through a summary trial, one side wins and the other side loses. Normally they will negotiate from that point. So it never actually goes to a judge. Mediation uses a neutral person, the mediator, to work with litigants and their lawyers to achieve a settlement. The mediator does not have authority to decide the controversy, but rather acts as a facilitator, meeting with each party in an effort to broker an agreement. And I think that's the way it works with you have mediators on the reservation. I think that's the way it works. People often prefer mediation because they are risk averse. They prefer controversies to be settled by them rather than to be decided for them. And that's the way it works in a jury trial. That's the way it works if you are meeting a judge. Compared to litigated divorces, research suggests that mediation encourages parents to comply with divorce agreements, remain involved in their children's lives, and renegotiate relationships in a more adaptive way. And this is what my daughter had down in Florida. They had a mediation, and then they went before the judge. Afterwards, they went before the judge. The mediator presented what she thought should be the decision, And as it turned out, well, it was kind of a strange situation. Um, my daughter's baby daddy, I don't know what else to call her. I call him asshole. The baby daddy was kind of a bully, and he didn't like women, as strange as that is. Strange situation. Why in the world would she ever get with somebody like that? But he kind of shot himself, continued to shoot himself in the foot because he treats women as if they're stupid. And the mediator was a female. So he kind of just shot himself in the foot. His lawyer was male and my daughter's lawyer was a female. And he kept denigrating females. So the mediator was a female and the attorney was a female. And he kept interrupting them and denigrating women. He kind of messed himself up. He assumed that they wouldn't let the child leave the state. That was his assumption. And the reason he thought that was because he's wealthy, or his family's wealthy. He's not wealthy, but his family is wealthy. So, you know, rich people always win in Florida, but not this time. But if we hadn't put up as much money as we did, the case probably would have, we wouldn't have been able to defend moving the child out of Florida. He's better off in Iowa anyway. It's a much better place to raise children. Worst state to raise children? Does anybody know what's the worst state? Of all the states in the United States, which state has the worst record as far as supporting children? It used to be New Mexico, but they've got a new governor that was a teacher, so, and they're changing lots and lots of things in there. Arizona's second after New Mexico. Not a real child-friendly state. But then again, you've got all those snowbirds coming down. So it's really difficult for people or for the state of Arizona to finance any education or anything, because a lot of the people in the state are retired, and they don't want to pay for the education of your children. They've already educated their children wherever they lived before.
Just want a vacation.
That's exactly right. And it's the same way in Florida, unfortunately. That's one of the reasons why the teachers in Florida are some of the lowest paid teachers in the United States. Right behind Arizona and New Mexico. My son isn't even making $40,000 a year. And he has 7 years of experience of teaching. Mathematics, which I have a hard time finding math teachers. Anyway. What form of ADR do people tend to favor? Participants favor the options that offer them control, a neutral third party helping disputants to arrive at their own resolutions and processes that allow disputants to control their own presentation of evidence. They like the whole concept of control. Anytime you allow yourself to be controlled by somebody else, you feel like you can't control your own fate. Should courts force litigants to try ADR before setting a case for trial? Attorneys like the process, believing that it is fair and saves clients time and money. Yeah, like lawyers are trying to save you money. But of course, they don't want to go to trial either because they might lose, so they would rather not go to trial. In the case of the ADR, they have a lot more control over the situation, so lawyers really like this type of resolution of conflicts. However, mandatory ADR can lead to an unintended effect. Some lawyers file meritless claims knowing that their claims will have settlement value in mediation. And you see these all the time on television. Mesothelioma, which has to do with asbestos. They're settling these cases all over the United States. But sometimes we're getting frivolous cases, individuals that that was on a ship once for 3 days. Now they're claiming that they have mesothelioma from the ship. Now they're suing the company that owned the ship. Doesn't make a whole lot of sense. They're only there for 3 days. How in the world did they ever get mesothelioma from that short period of time of exposure? So there's a lot of frivolous cases out there, and that's one of the problems with allowing them to do these kinds of things. Problem-solving courts were developed to rehabilitate and monitor individuals in the community rather than incarcerate. These alternatives pertain to criminal law only. A lot of drug laws, minor criminal laws, not felonies, misdemeanors, but not felonies. 3 major justifications have been offered for the development and expansion of such community alternatives. Humanitarian, its cruel and unusual punishments may not be inflicted in these courts. They can only incarcerate you for a short period of time. The cost is much less, of course. Correctional facilities house inmates who as a group have wide-ranging rehabilitation needs, and for this reason, these non-standard courts are being used all over the United States. When populations are more homogeneous, as with if everybody is if they're in rehab, the entire population has drug problems rather than any other type of problem or mental illness, they're more likely to receive the treatment that they need. The sequential intercept model was proposed by Munetz and Griffin in 2006. It identifies 5 stages of criminal justice process at which standard steps could be interrupted and their community treatment alternatives substituted. And of course, you can, with the sequential intercept model, you can put the person in a specialty court at any point during the 5 stages. Intercept 1 is law enforcement and emergency services. When individuals with behavioral mental health disorders encounters any first responder, it can result in arrest, criminal charges, conviction, and incarceration. Only about 0.3% of the police encounters are with people suffering from mental illness, but it is increasing, of course. We released all these people. Once upon a time, we actually had mental hospitals in every state. The federal government closed them down. They stopped federal funding for the mental hospitals. This was during the Reagan administration. They closed all of the state hospitals. They stopped the funding for the state hospitals. And most of the states closed down their mental hospitals. So all of these individuals, what happened to them? Where did they go? Where did all the people with all these mental illnesses go? They went out on the street. They had no other place to go. And of course, it was the most brilliant thing that anybody ever did. Well, I'm sorry, presidents are always, everything they do is brilliant. No, wait a minute, that's just Trump. What am I talking about? Nobody blamed the guy. You know, as a psychologist, I didn't like Reagan anyway, but as a psychologist, I'm going, you can't do that. What are you going to do with all these people suffering from schizophrenia? And they didn't have an answer, and they didn't care. They were happy that they didn't have to pay for it anymore. They didn't have any more federal funding for them. They took it all away. Reagan did a bunch of other stuff. Wait a minute, who was president? Oh, Jimmy Carter built all of these HUD houses on the reservations. But they weren't done by the time Reagan took over in 1980. And Reagan he didn't believe you guys should have your own reservations. He didn't believe in reservations. So he decided he would take away all the funding for all the fixtures inside the houses. And that's what he did. He took away all the funding for plumbing. So that's why if you wander around reservations around Indian country, what you'll find is a lot of the houses have the plumbing on the outside, or exposed plumbing. And the reason is because they put in the plumbing after, it was Clinton that financed all the plumbing, but Reagan took it away. And Bush didn't do anything about it. And then Clinton's the one who decided, my God, we got all these houses without any plumbing. So he's the one that put all the plumbing in. As funny as that is. Let's build all these houses and not put any plumbing in. That's Ronald Reagan for you. But he's the one that took away all the hospitals. In some encounters, arrest is unnecessary, of course. They've got a mental illness, they're screaming or they're creating some kind of a disturbance. All they need to do is quiet them down and they don't have to arrest them. However, with training, these incidents can be controlled instead of escalating into more dangerous situations. This can be a job for specialized police responding through crisis intervention teams. We talked about crisis intervention teams before. The individual that worked here, Dawn McDonald, was a social work instructor, and she had been on one of the crisis intervention teams in Marion, Indiana, as odd as that may seem. And she, whenever they found an individual that was not making a whole lot of sense, was strangely violent, of course, they would call in her crisis intervention team. And normally they didn't have to incarcerate. Normally what they would do is they would take them, they would either put them in an isolated jail cell until they quieted down, or they would take them to a mental hospital for a select amount of days that the state would pay for. Intercept 2, post-arrest initial detention, initial hearing, and pretrial services. After an arrest has been made, the individual will be brought before a judge to determine if a crime is serious enough to warrant a trial. This is your first appearance. This has to happen within 48 hours of arrest. They have to go before a judge in 48 hours. They have to accuse them of something. If they don't accuse them of something, they have to let them go. With these cases, with a case of somebody that is mentally ill, sometimes they will send them to the specialty court instead. At this point, if the mental health intervention is more appropriate, the judge may remand the arrestee for mental health evaluation. Intervention can also take place when drugs are being used or domestic troubles are part of the problem. So we're talking about domestic violence courts, and we're also talking about drug courts. Intercept 3, post-initial hearings, jail, prison courts, forensic evaluation and commitments. If the individual has a special problem that can be solved outside the criminal courts, they may see a specialized court, a drug court, a mental health court, a homeless court, a domestic violence court, or a community court. The use of these courts to improve people's lives is called therapeutic jurisprudence. We don't do this around here. I guess you have a court here on the reservation that it's kind of like a community court. And
What's a homeless court?
homeless court, homeless people get arrested for vagrancy. They get arrested for a lot of strange things. A lot of cities try to control their homeless population with all these frivolous laws. You can't stand more than 15 minutes in front of the store. All those. These are mostly vagrancy laws. Homeless court takes care of these individuals and tries to give them something to do. Clean up the community or whatever. They give them things to do. So a homeless court is usually held in a homeless shelter. I mean, that makes sense. The court that's not on here is the Veterans Court. Sometimes veterans have problems that other people don't have. Usually it has to do with PTSD, has to do with violence and PTSD. So they will have a Veterans Court. So instead of arresting the guy for assault, he'll go to the Veterans Court and they will send him to some kind of treatment for his anger issues, which normally stem from PTSD. So Now, these are specialty courts so that we don't have to incarcerate these individuals. If we incarcerate them, it's not going to help anybody. There's no rehabilitation that's going to take place. But if we can send them to a drug court, of course, they won't be incarcerated. They'll be sent to some form of rehab. And this is known as therapeutic jurisprudence. The courts there's two reasons for the courts. One is to protect the individual that is being arrested. The other is to protect society. Well, too often we look at protecting society and we don't care about what happens to the guy that gets arrested. So it really all depends on the state, it all depends on the politics of the state, it all depends on what's going on in the nation at the time. A lot of times our courts become a little bit too stringent, and we just incarcerate people for reasons that don't make any sense. The premise is that the legal system should help troubled individuals cope with the chronic problems that brought them into contact with the criminal justice system. So we're trying to keep these people out of jail, is what we're trying to do. We're trying to deal with them in another way. The collaborative, non-adversarial nature of specialty courts in which judges work side by side with mental health professionals, community agencies, and offenders themselves focuses more on meeting the ongoing needs of participants than on punishing them. And that has something to do with our courts as well. Are the courts there to punish people, or are they there to help people? Law enforcement, of course, they are there to serve the public, to protect the public, but also to serve the public. The courts should be there for the same reason, not for punishment, except in certain circumstances. This approach, in which the law is used as a vehicle to improve people's lives, is of course referred to as therapeutic jurisprudence. Drug courts divert cases from the traditional criminal justice system and link drug-addicted offenders with treatment programs and extensive supervision. The reality is that if we are trying to stop drugs in our community, a lot of times we will arrest anybody that are using drugs. Now the reality is the only people that should be arrested are the pushers, are individuals that are the suppliers, the individuals that are making money off of the drugs, not the individuals just using the drugs. So the other question comes up, and you can answer this question any way you like: is there such a thing as a victimless crime? Prostitution is considered a victimless crime by some people. And other individuals, they say, no, look what's happening here. This individual, individual who is turning the tricks, this person is being damaged. So is it a victimless crime? And if it is a victimless crime, how do we stop it if this is a crime? This is a really strange philosophical question, because their prostitution is legal in most of the world.
You almost said all.
Not all the world, but in most of the world. If you go to Germany, they have brothels. They have brothels, big buildings, nice places, I guess. I've never been in one, but they have prostitutes standing on the side of the road. Same way in Holland. Holland has the famous red light district of Amsterdam. So prostitution is one of those, and that's a huge question. If this is a victimless crime, what do you do with it? You make it illegal. Well, it's illegal in the United States, and it's illegal every place in the United States except that one county in Nevada where it's legal. And I don't know how they did that. It's not legal in Nevada, but it's legal in that one county in Nevada. The county right outside of Las Vegas. Anyway, we'll talk about victimless crimes next time and what should happen. All the marijuana laws. We have all these people that are being incarcerated for pot, and in 10 states it's legal to smoke pot. So what happens every place else? We'll talk about this next time.